Why would I ask a doctor in a medical malpractice case whether it's important to keep accurate records in this patient's case? You want to know the answer? Come join me as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law here in the state of New York. So now I'm at trial. My very first witness at trial is the doctor that you have sued. And now I have an opportunity to question this doctor as if I'm cross-examining the doctor. I get to ask leading questions. And one of the questions I want to ask the doctor is, Dr. Jones, isn't it true, and wouldn't you agree, that it's important for you as the patient's treating doctor to keep accurate medical records? Objection! He can't ask that question, the defense attorney says. And what do you think the judge is going to say? Objection overruled. That's what the judge will likely say, and what that means is that the question is proper, and doctor, you have to answer the question. So what was the question again? Doctor, would you agree that it's important to keep accurate medical records? He's got to say yes, right? Now, why would I bother asking the doctor that you have sued, you believe violated the basic standards of medical care? Why would I ask such a simple, basic question about whether or not he agrees that it's important to keep accurate medical records? It's important because I want the doctor to acknowledge and recognize how critical it is to keep accurate records. Because later on, I'm going to show him and show the jury that his records are less than accurate, that his records are less than thorough, that his records are less than detailed. By having him acknowledge and recognize that it's important to keep accurate records, now it shows to the jury that the doctor knows what he should do, but in fact didn't do in this particular case. So how does that help us in proving our case? Well, you should know that we only have to show that we are more likely right than wrong in what we are claiming is true. And this may be just one little element of the doctor's care and treatment of this patient. In many cases, the defense will argue, hey, look at this guy Oginski, he's making a whole big deal about the fact that the doctor didn't have detailed and accurate and thorough notes. And then he's going to argue, hey, that improper record keeping did not cause any injury to the patient. And you know what we say to that? You're absolutely right. We agree with you 100%. The accurate record keeping, or the lack of accurate record keeping, didn't cause the patient harm, but it establishes a pattern to show that the doctor was careless in his record keeping. And now we've also shown you that we're more likely right than wrong, that the doctor was careless in the treatment he rendered to this patient. So it's just one little element, in addition to everything else, that the jury will evaluate to determine whether we are more likely right than wrong. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in a medical malpractice trial here in the state of New York. You know, I realize you've got questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you're contemplating bringing a lawsuit and you've got questions, what I encourage you to do is, you know what I'm going to say, right? Pick up the phone and call me. I can answer your legal questions. You know, I do this every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, @ oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.